Are we ready for Mr. Shadowins?
Yes, Your Honor.
Come on up, Mr. Shadowins. And I know that the bonds person also had mentioned that he wanted to address the court, but anyway, for the record, this is 25T448, 25M352, 25M395, 25M375, 25M318, all people v. Joseph Shadowins, who appears in person in the courtroom. Mr. McKissick from the District Attorney's Office appears in person as well. You're standing, so Mr. McKissick?
Yes, so I was able to speak with the defendant a little bit about kind of the 5 cases coming up. It doesn't appear that we'd be able to reach a resolution considering some of the things that I would have pointed to as direction for the defendant doesn't seem like something that they would be willing or able to do. This would include picking up one of their issues that they haven't been given any discovery on any of these cases. I let the defendant know that I myself do not give or take in discovery. That's something that can be asked for from the district attorney's office by going there physically and then asking for the discovery, which would be handed over at that time. The defendant let me know that that would not be possible for them, that he was told that if he were to go to the district attorney's office that he would be arrested. It's not typically something that the district attorney's office would impose a arrest for someone coming to pick up discovery without some other maybe factors that haven't been mentioned. So I'm kind of at an impasse as to what to do. It seems like many of the asks by the defendant is not something that I can readily take care of, even though that would be a simple solution, is just going down to the DA's office and getting up discovery. But moreover, he's asked me to take some of his own evidence, which is not something that I was willing to take at this time. I think from a procedural posture in this case, we're once again at an impasse. I think the defendant claims that they're not a sovereign citizen, even though many of their arguments align fully in place with many arguments that I've seen from sovereign citizens. He's asking for a change of venue to a basically a court that we don't have in the state, common law court. So like I explained to them, this precedent that they're brought up is kind of their argument, or perhaps their defense. It's not a valid argument, and there's nothing that I can do as a prosecutor to have the case moved to a court that doesn't exist, essentially. So I'm not exactly sure what to do.
Okay, Mr. Shadowins.
Thank you, sir. I'm here by special appearance this morning.
Mm-hmm.
So I am not, on and for the record, a sovereign citizen, nor have I ever been a sovereign citizen, though I agree with the state's position that many of the claims and statements I make are in alignment with that. I have clearly corrected my status as de jure on and for Teller County records that this court has admitted they haven't read. I have filed motions to dismiss many of these cases based on those records, and the subsequent motion to dismiss, Your Honor admits on record she has not read and denied. So I am not aware of any victim. The evidence I was trying to give the state this morning with respect to an alleged victim are rebuttals to affiance. So I do not qualify for an attorney. I cannot afford an attorney due to damages from the state, nor can the state provide a common law a defense with the assumption that I am a domestic terrorist. That is a clear conflict of interest. Your Honor herself has admitted multiple times on record in multiple cases calling me a sovereign citizen, refusing to answer my questions, dismissing them as sovereignty arguments, and so on and so forth. This is clearly due process issues, clearly conflict of interest issues, and I cannot plea or proceed without full discovery of facts, evidence, and elements. There are also issues on the docket today that Ms. Hudgens' name is under. I have never consented to an attorney. I have no discovery. I have no complaints. I have not even basic discovery. So how can I defend myself if I can't speedily rebut claims?
Okay, so thank you, Mr. Shadowins. So what I'm hearing is there's an issue about discovery. You know the process to get the discovery, which is to go to their office in Colorado Springs. They have a discovery, apparently some kind of office. And you can obtain all the discovery in these cases. If you hire an attorney, that attorney could also go and request that discovery. And what's the problem with that, sir?
I have receipts. I have emails from DA's office saying, do not come here, we will arrest you.
Where are they, sir?
I wasn't prepared to make that argument. I tried to give evidence of rebutting of affidavits today. Prosecution won't take it. Non-response from the DA's office times 2 prosecutors.
Stop, let's
You-
stop.
allow
I'm
me to
trying
speak, please.
I'm trying
Please
to
do not
get,
rush justice.
can we get
I'm
an
trying to
answer?
answer your question.
Well, I hear that you're saying that you don't have anything
I don't have it
from.
with me today,
Okay,
but I have emails to multiple prosecutors plus Ms. Schaaf, senior investigator, requesting discovery disclosure of evidence. I was told I could go to the police station to pick it up, denying the fact that I have restraining orders from multiple police officers for whistleblowing. Okay, I can't go to pick it up in person because cops took my truck. That was the principal issue leading to all of these cases, a driving versus traveling issue deemed sovereign citizen arguments. I have never been a sovereign citizen. I have common law standing on file with the county, and I cannot get a common law court. So at this point, I don't know how to proceed without evidence. I can't plead without evidence other than non-assumpsit by way of confession and avoidance and invoke my right to subrogation.
the problem, Mr. Shadowins, is you say that you are not a sovereign citizen, but as I would agree with Mr. McKissick, your arguments are in alignment with arguments that sovereign citizens make.
Which is a
So what
conflict
I'd
of
like
interest.
what I would like to say, I'm not making the argument, it's you
You
are.
called me a sovereign citizen yourself, Judge.
So I would say at this point, Mr. Shadowins, that your arguments do align with sovereign citizen arguments.
Object, personal opinion bias.
I getcha. So it looks like you have someone here who perhaps could take you to the district attorney's office in Colorado Springs, although I know because of your past failures to appear, he's had to post bonds, and I think he had some questions about that. But-
Yes, do I have clearance to not be arrested if I go and try to petition for discovery? I do not wish to motion for discovery with jurisdiction issues raised by the state not affording me the opportunity to rebut. The state twice raised the issue of jurisdiction, and I was not afforded a rebuttal. These affidavits clearly rebutted, and there's no notary present in the court today. Mr. Kissick will not allow me to submit evidence in my defense.
So, the thing also, Mr. Shadowins, is it's very confusing to follow your arguments.
That's because I'm common law and you don't recognize that, which is the bias and conflict of interest.
That is absurd. That is an absurd argument, Mr. Shadowins, and I will not.
Objection, personal opinion.
Thank you.
Bias.
I have made my ruling. It's absurd. So here's what I would, I did, and I will say that I did read the documents that you did file, Mr. Shadowins. Even though your handwriting is not easy for me, I had to, the last thing that you filed, your motion to dismiss, was filed on the day of your last court appearance, and I did not have the time to look at that beforehand.
Motion to reconsider?
Okay. That makes no sense. Haven't ruled. You only asked to reconsider if I've already ruled.
You dismissed my motion.
I have not,
You dismissed my
told
motion to dismiss based saying that you hadn't read it. I take no adversarial position.
Mr. Shadowens, the reason that I told you I hadn't read it is because it would take me some time to go through it.
Understood.
So I'm not I did not rule on your motion at the last
Deny
hearing.
it.
In regard to due process of law, I went through your motion for dismissal, Mr. Shadowens, and in regard to due process of law, there's really no clarity about what specifically you're concerned about, but you have, as far as due process rights to be heard and to, let's see, to understand, well, to be heard and to have really, it says no one shall be condemned without an opportunity to be heard. So you have had the opportunity to be heard. You've appeared in court. There is no violation of due process of law. In regard to the Sixth Amendment, also I will find, as far as due process of law, if your concern is about the statute, the court is, there's nothing specifically about any of the statutes of which you're alleged to have violated, which you've not said, oh, they're not sufficiently clear to persons of ordinary intelligence to afford a practical guide for law-abiding behavior and capable of even-handed enforcement. All the statutes in these cases that have been charged as violations against you, court does find that they are sufficiently clear to persons of ordinary intelligence, and they are capable of even-handed enforcement.
I don't even
In
know what that
regard,
means, Your Honor.
wait,
I'm not-
I'm responding to you raise these issues. You write due process of law with no real explanation. I have to make assumptions about what that means.
Objection, the court would not hear it.
In Sixth Amendment,
Dismissing it as sovereignty arguments, end
I
quote.
have not dismissed, I am ruling right now,
You
Mr.
can't rule, you haven't heard the
Mr.
matter.
Shadowens, I did read your motion and I am ruling right now, so be quiet. In regard to the Sixth Amendment, that the Sixth Amendment provides for speedy public trial by an impartial jury, informed that you be informed of the nature and cause of your accusations, that you are confronted by witnesses against you, have a right to subpoena witnesses and right to counsel. You have all of those rights. None have been denied to you. In regard to obstruction of justice, there's no, the court denies that or dismisses that argument. There's no specifics. It just simply says obstruction of justice. Prosecutors refusing to respond with discovery, court denies that. Court notes that the district attorney has provided information how Mr. Shadowens can obtain that discovery. In regard to state can't be an injured party, the state does file the cases to enforce public laws and publish violators. The primary goal of the state is to ensure justice for the community, not just a specific individual's loss. So that is, so I deny your
Point of clarity,
dismiss.
please. Objection, point of clarity.
No, sir, I am ruling. It's my opportunity to talk.
You're not hearing me.
You can write down what you.
I did write it down. You're not reading the complete statements.
No,
You're
sir.
not reading the complete, I'd like to read the records for the record.
No, I don't, no, you're not going to be reading
Let the
that.
record show the court. is
You
denying
can
me a
always
defense.
file that, Mr. Shadowens.
I
I
did.
have-
It's on file.
All right, I've ruled that, that nothing about the state, the fact that all your cases are the state of Colorado versus you does not prevent those cases from proceeding forward. Those cases will continue. In regard to change of venue, there's no reason under Rule 21A of the Colorado Rules of Criminal Procedure to find that you would not be able to obtain a fair or expeditious trial in Teller County. So I deny that request at this time. If you wish to submit some additional information about why you think there should be a change of venue under Rule 21, you should follow the rules there.
I do. It's
The
right here. I'd like to
irrevocable-
read it for the record. please.
Irrevocable trust is an absurd argument. Traveling, not driving. I did rule on the record in this, on that issue before. In People v. Zen, the right to drive a car on public roads is not a fundamental right. States do have the right to regulate the use of motor vehicles on roads in this state.
Revoke the claim of a
so that-
contract of a
so
valid
that-
driver's license.
So that argument regarding traveling, not driving is denied. Impossibility to obtain your driver's license. I have no authority over the Department of Motor Vehicles. That's something you will have to deal with the Department of Motor Vehicles about. You have been in this courtroom all morning and heard different people talk about their efforts to obtain their driver's license. You can certainly get that information from the Department of Motor Vehicles. In regard to WebEx authorization, you are authorized to appear by WebEx, and you have appeared by WebEx on the last court date. Again, you raise the same issue regarding discovery. I have already advised you that how you get that discovery. All I can do is say, well, if the clerks did not get message regarding your request to appear by WebEx, and that's why you had a failure to appear, we do the best we can. We're not perfect, but we do try and get information to you as quickly as possible. Again, you have no injured party, the victim listed as the state of Colorado. Again, that is not the state of Colorado. Represented by the district attorney's office is representing the rights of the public
And the judge and the jailer and the.
to enforce the laws. No, anyway, you can interrupt and try and prevent me from saying things.
Not
Mr.
reading the
Shadowman.
record.
I am reading it and.
I object.
I understand you object, and that's
I heard
fine.
my objection.
No, as far as a valid warrant, you actually did have valid warrants in 25M375, 25M352, and 25M318. You also had summonses in 25T448 and 25M395, which are authorized under Rule 4.1 of the Rules of Criminal Procedure. So I have ruled on your motion to dismiss, and it is denied. All right?
May I approach the bench?
Why? Why?
Evidence.
I don't need your evidence at this time. Evidence is generally something you present at trial. So,
Understood. Thank
That's
you
fine.
for the point of clarity. I'm going to allow this gentleman to address bond.
1 second.
I'm going to plead non-assumptive.
But
Okay?
that isn't a plea, but I can enter a,
Not
I can
guilty.
enter a guilty plea for,
Not guilty.
not guilty, sure.
Not
I
guilty.
can enter not guilty
And
pleas
please
for you.
appoint
But
assistance of
first-
counsel.
No, hold on. I need to go through some questions with you. I have to give you the Arguello advisement because.
Sorry, the what?
It's called the Arguello advisement. It's based on a case 772P2 87. I have to ask these questions of you since we are setting all your cases for trial and you have no attorney. Do you understand that anything you say can be used against you?
Yes.
Do you understand you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, one will be provided for you free of charge? You have to apply for the public defender and see if you're
I don't
eligible.
qualify.
Okay, all right. Do you understand I will appoint counsel if you want an attorney to represent you? Of course, you must be eligible financially for their assistance.
I'm not due to injury from the state.
All right. Do you understand the charges against you are
No.
multiple, Mr. Shadowens? You have failure to display proof in 25T448. There's failure to display proof of insurance, which is a class 1 traffic misdemeanor carrying possible penalties of 10 days to 1
Due to
year.
disability,
10 days to 1 year. in the
Impossibility.
county. and or $500 to $1,000 fine. You're charged with driving under restraint, a Class A traffic infraction, carrying a fine. You're also charged with having a fictitious registration plate, which carries 10 to 90 days in the county jail and or $150 to $300.
I have a rebuttal.
You also have a registration, unregistered vehicle, which I believe is a Class B. Give me a second. Traffic infraction, I believe. 5448.
I have a rebuttal, Your Honor.
No.
I'd like to read a record on for the record, which reads, and I quote,
I am doing the Arguello advisement, Mr. Shadowins, which means I have to go through all your
I don't
charges.
have an attorney.
in 5
I don't have an
cases.
attorney. I
I
can't
know,
defend
and
myself
that's-
on 5 cases with no evidence.
That's
I
what-
would just like to read a record
No.
and get an
Not-
attorney.
Not.
Can we set the matter over when I speak to counsel, please? I have disabilities.
Are
I'm
you going
really
to
overwhelmed.
hire counsel, Mr.
I can't
Shadowins?
hire counsel. The court said they would appoint attorney. I don't apply. I don't qualify for a public defender.
I'm gonna-
Even though the public defender is named on some of these cases, I've never spoken to, Your Honor.
We'll take them off. We'll make sure her name is off of that. But I am right now in the midst of the Arguello advisement. We're going to set your cases for trial. You're entering not guilties. We're setting your case for trial and pretrial readiness. To do that, I have to run through these questions with you.
Thank you for the
in
point of
order
clarity.
to-
Can I take a moment to recess, please?
Why?
Because I have service-connected disabilities to include PTSD and schizophrenia, and I'm extremely overwhelmed due to the nature of the adversarial nature of this proceeding.
Okay, go ahead, sir.
When would you like me back?
Give you 5 minutes. I'll give you 5 minutes.
To address,
5 minutes.
to address bond, please.
5 minutes out there. Tell me what your name is, sir, and come on up to the podium.
John Maynard. I posted a bond for
What's your name?
John Maynard.
Yeah. Hello, Mr. Maynard.
Good morning.
And what is your, what's your concern right now? I'm just
My
trying.
question was,
Asking.
what are the criteria that will release the bond that I posted for Mr. Shadowins? Was his appearance today adequate to release it?
No, generally what the bond paperwork, and let me just pull up, looks like, for example, you've posted the bond in 25M375. The bond paperwork requires that he appear today and at each place and upon each date to which this proceeding is transferred or continued, or until entry of an order for deferred prosecution or deferred judgment, plea of guilty, nolo contendere, or conviction to answer charges. So it isn't until the end of the case that it's released.
Okay. All right. Thank you.
Sure. All right. And that would apply to all the cases that you posted bond on. All right, back to Mr. Shadowins. He's back in the courtroom.
Apologies, Your Honor. I just needed a drink of water and a breath. Thank
That's-
you.
That's fine. All right, and then the last charge there is a Class B traffic infraction, which it carries a fine only. The next case is 25M352, in which you're charged with harassment, insults, taunts, 352.
Against who?
So that is against Chantel Natalie or Natalie Chantel.
Entire complaint is hearsay.
Uh-huh. Well, you would be,
I'll
we're
deal with
setting
that
the
if-
case for trial, exactly, and you can confront any witnesses against you, certainly. But so in that case, you're facing potential penalties of, let's see, a Class 2 misdemeanor carries possible penalties of up to 120 days in the county jail and or up to a $750 fine. You've also got disorderly conduct and trespass in the 3rd degree, both petty offenses, carrying possible penalties of up to 10 days in the county jail and a $300 fine. Then we have 25M395, in which you're alleged to have resisted arrest, a Class 2 misdemeanor, up to 120 days in the county jail and or up to a $750 fine. In 25M375, you're alleged to have 25M375. In that case, you're alleged to have provided false reporting of identification information to police, also a class 2 misdemeanor, up to 120 days in the county jail, and or up to a $750.
What named identification?
The affidavit for arrest warrant indicates that you gave false reporting information to Officer Lupia. You said you reported, you called 911 to report you were being gang stalked by law enforcement. Call screen, as he would not be held responsible if he were to defend himself. Call screen. Joseph told dispatcher that law enforcement had kidnapped him and stolen his vehicle. Joseph is referring to regarding being kidnapped and having his vehicle stolen was when WPPD conducted a traffic stop while he was driving the vehicle. Probable cause was established for multiple violations and the vehicle was towed. He got a voluntary, so it's false reporting to law enforcement. That's what
Thank you.
they're saying. All right. And then we have 25M318, which is, excuse me,
Bless you.
25M318. Sorry, I'm just trying to get to what that next one is. That in that case, the charges are harassment, strike, shove, kick, which is a class 1 misdemeanor carrying possible penalties of up to 364 days in the county jail and or up to $1,000 fine. You're also charged with false reporting, fake crime, which is a class 2 misdemeanor carrying possible penalties of up to 120 days in the county jail and up to a $750 fine. So, Mr. Shadowins, you are facing some pretty substantial possible penalties. Do you understand? I know you disagree with the charges, but do you understand the charges and the possible penalties?
No, and I reject all charges.
Okay. Do you have any legal training? Do you have any legal training, Mr. Shadowins?
Not in statutory law. I am only learned in common law, which this court does not recognize, nor Article 3 of the Constitution by your own omission. So I cannot get a fair trial in this court.
Gotcha. How far have you gotten in school?
I don't wish to answer any more questions. Further, I say no and stand mute.
Are you suffering from any mental health problems? What mental health problems, sir? Any mental health problems I should be aware of? Are you competent to proceed, sir? Or do you want me to have, or do I need to have the Colorado Mental Health Institute, CMHIP, conduct an evaluation? They can send a psychiatrist who would talk to you and see whether or not you are competent to proceed. Do you think that would be helpful to determine if you are competent? No response. Are you suffering from any mental health problems? You seemed to say you were. There was a nod in that respect. What is your desire with respect to appointment of advisory counsel to assist you in preparing your defense? No response. Okay. So bless you, given that Mr. Shadowins seems to feel or is indicating that he has mental health problems, I'm going to
Objection assumptive.
I'm going to issue a mental health stay, and I'm going to order competency evaluations in the cases here. So it will be a condition of the bond, Mr. Maynard, so this is going to be a condition of his bond as well, that he cooperate and do the evaluation by the psychiatrist. I am going to do an additional advisement to you, given that I'm going to order a competency evaluation. At this time, the court has determined it has insufficient evidence to make a preliminary finding regarding your competency to proceed. The court is going to order that you undergo an evaluation regarding your competency to proceed. The court will now advise you of the nature and consequence of the proceeding and of your rights under 16-8.5-109. Before you talk with anyone, you have the right to have an attorney appointed and to confer with your attorney. You will undergo an examination concerning your competency to proceed. You will be examined by one or more psychiatrists or psychologists. You have the right not to say anything to the psychiatrist or psychologist. You shall cooperate with the competency evaluator and with other personnel providing services. Statements you make during the evaluation shall be protected as provided in 16-8.5-108. Statements you make during the examination cannot be used against you during the prosecution's case in chief, but can be used as rebuttal or impeachment or during sentencing. If you choose not to cooperate with the competency evaluator and other personnel, and the lack of cooperation is not the result of a developmental disability or a mental disability, the fact of your non-cooperation may be admissible in your competency or restoration hearing to rebut any evidence you introduce about your competency. Further, if you are non-cooperative with the competency evaluation, an evaluator may render an opinion of your competency based upon confessions, admissions, and any other evidence of the circumstances surrounding the commission of the offenses, as well as your known medical and social history. The opinion may be admissible into evidence at your competency or restoration hearing. By raising the question of competency, any claim of confidentiality or privilege is deemed waived, and all parties will have access to competency evaluation reports, information, and documents relating to the competency evaluation that are created by, obtained by, reviewed by, or relied on by the evaluator. A written report of the evaluation will be prepared and provided to defense counsel. Well, if you have an attorney, to your defense counsel. It will be provided to the district attorney and to the court. Within 7 days after receipt of the report, either party may request a hearing or a second evaluation. If you are found incompetent, you will be ordered to undergo competency restoration. This can take place on an outpatient or an inpatient basis. During that time, you are entitled to a hearing as to whether your competence has been restored. At a competency hearing, you and the prosecuting attorney are entitled to be present in person to examine any reports of the evaluation or other matter to be considered by the court as bearing upon the determination, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make opening and closing statements and arguments. The court may examine or cross-examine any witness called by you or the prosecuting attorney and may summon and examine witnesses on its own motion. Once your competence is restored, we will resume these criminal proceedings from the point that we are at now. All right.
Let the record show Your Honor proceeded with an objection she didn't answer to. The court didn't respond to my objection. Are you assuming that I am incompetent? You said I'm being restored to competency.
I don't have enough information to
Okay, thank you
determine
for
whether
clarity, but you had an objection and proceeded without. So I'm challenging jurisdiction in all matters, and I rest, and I'm not the defendant here. I do not accept the charges.
Well,
State
sir,
is ordered to prove up the claim of a contract in any of these matters.
of course, the people have the burden to prove all charges.
Well, how can they?
Elements
You're
of
making
each
an
charge.
entire case for them, colluding with the same.
when the
Clear conflict of interest.
the people have the burden to prove beyond a reasonable doubt, each element,
So
all
they have-
elements of each charge beyond a reasonable doubt.
Can't-
Right now, we're on a stay, sir, because we're not proceeding any further in the cases.
Where's my evaluation?
Um,
Your jurisdiction is challenged and cannot proceed absent proof of jurisdiction.
Okay,
See U.S.
Sir,
Supreme Court Hagan versus Levine.
so I have authority over your criminal cases under Article 6 of the Colorado Constitution, Sections 1 and 16, and CRS 136106. I have subject matter jurisdiction under Article 6 of the Colorado Constitution, Section 17, CRS 18-1-201.
Are you colluding with the prosecution?
13.
It's,
No, sir.
are you claiming that that's evidence
These are,
for the prosecution? The state is making the state's position?
sir,
I just want my competency hearing date, and I want to get out of here. This is clearly a witch hunt.
I am
I'm
telling
done.
you, I am responding to
No,
your
no, you're
argument.
not. You're
What-
litigating for the prosecution,
I am
who
not.
does not have jurisdiction.
I am not. I have to find that I have jurisdiction, and I do.
Objection.
So stop, sir. I'm going through the statutes to tell you, Section 17 of Article 6 of the Colorado Constitution and CRS, these are
Prove up the
statutes, sir.
claim that I
18-1.
signed that and agreed to any of that.
18-1-201 and 13-6-106. I have personal jurisdiction as the result of the issuance of a summons and complaint or warrant. The summons and complaint.
Which you did not allow me to rebut.
4.1. And then I have, in regard to traffic cases, again, I have jurisdiction over the case under Article 6 of the Colorado's Constitution.
Section circular laws are
Sections-
just not proof.
These are set, this is a separate category of cases. You have criminal cases and traffic cases. Sections 1, 16, and 17 of Article 6 of the Colorado Constitution and 42-4-7.
The record shows he's colluding with the
the-
prosecution.
Of the, I'm not responding to that argument because
Good.
it's also ridiculous. You stated, Mr. Shadowins, or challenged my jurisdiction.
It's still
I'm
challenged.
telling you, I have jurisdiction. I've given you the sites. I've given you
You
that
cannot make
information.
the entire case for the prosecution. The
am
state cannot
not-
be a party to the state
I am
adjudicating
not-
and jailer, judge, jury. That's a blatant conflict of interest.
I am not-
Motion for change of venue.
It is denied.
Reconsider for motion change of venue due to blatant conflict of interest.
Denied.
Jurisdiction is challenged. What do I
have-
say? Not
I
to
have-
stand mute.
I have told you, Mr. Shadowins, it is my responsibility in any case that I make sure that I have jurisdiction. These are the statutes and constitutional provisions that give me jurisdiction over your cases. It will be the people's burden to prove the elements of the cases beyond a reasonable doubt. That is not my job. My job is to make sure I have jurisdiction, which I have told you that I do have. I will also I will be issuing orders for competency, What did you say to him, sir?
I asked him if he wanted to
Would you
get in a
like-
fight here.
Would you like to, so you're not to talk to him in here, sir. Please do not turn to him. So Mr. Shadowins, I am going to be issuing orders for your evaluation. And it is a condition of your bond or summons that you comply with those, with the evaluator. And then if you are determined to be competent, we will then proceed forward on your cases. If you are determined not to be competent, then I will be ordering that you undergo treatment that will help restore you to competency. Any questions, Mr. Shadowins?
When's the
Oh, we'll set a court date.
The
In a
date
process-
for the competency, is this a court proceeding or an evaluation with a doctor? How does
It's
this
an
work?
evaluation with a doctor.
And how am I supposed to get there with no conveyance?
Well, they will call you and you'll have to figure that out, I guess. I'm not
Consent to any of
exactly
this.
sure. Well, it's a condition of your bond, so if you don't do it, Mr. Shadowins, I'll be revoking bond, which is not helpful to your friend who posted
I
those
thought you-
bonds.
I wasn't here when you dealt with the matter.
Okay.
I appeared, he gets his money back. There is no bond. It's
No,
settled.
he doesn't get his money back until the cases are concluded.
I can't conclude the case if the state won't hear
Okay.
my arguments.
So, but Mr. Main, I want you to know that if you don't cooperate with your competency evaluation, that I will revoke the bonds and issue warrants for your arrest, and then you would have.
Threats, duress, and coercion.
I just want you to know that you told me you were not going to comply.
No, I objected and you failed to rule on it.
I have ruled on it. You objected and you were saying that you were not.
When's the date, Your Honor? When's the date?
You were saying that
I'm leaving.
you were saying you were not going to comply with the competency
I
evaluation.
didn't say any of that.
Okay. All right. The next court date will be.
Ridiculous. I made no statements for this record to any effect.
Well, it's all on the record, Mr.
I never addressed the issue of competency.
I am raising it on my own motion because I'm concerned.
Just give me the date, Your Honor, please.
I am concerned about your competency.
I'm concerned about your competency to have a license to practice law.
Thank you, sir. February 23rd at 9 a.m. So I'll be providing phone numbers and contact information for you, Mr. Shadowin.
How will you be providing that?
I will have, it's part of the order. I have to send it to them so they can contact you. Okay?
No, it's not okay. This is a grave injustice against a disabled veteran. Shame on you.
Okay. I'm trying to protect your rights.
No, you're not.
Because
You lit fire to my rights and threw them in a trash can and then tried to call me crazy without evidence and without a defense.
thank you, Mr. Shadowins.
We're done. The jurisdiction remains challenged.